Thanks for coming by. You see the title. Obviously, in this episode, we're going to discuss how judges read the Constitution. This is a topic that's really fascinated me, essentially because, I study language. It's kind of a personal hobby that I have. And I've always found it interesting how judges understand language when they interpret statutes in the Constitution or in federal law generally, and then how they apply those. And generally, that requires strong linguistic skills such as understanding, vocabulary and verbs and things of that nature, but also understanding how to reference historical sources properly in order to form correct judicial opinions or, what we perceive as correct. And this is essentially going to function more or less as a type of seminar type style presentation. So I would be glad to accept your questions. If you have any questions, leave them in the comments. I will read them and I'll try to, go through them at different points within this episode and display them, and we'll discuss them, obviously, if they're meritorious. So, first things first, let's go ahead and display what we got on the screen today. So, how judges read the Constitution. Constitutional interpretation and judicial method, a doctrinal lecture on judicial review, interpretive method, precedent, and birthright citizenship. And the reason we're using birthright citizenship in this is simply because this is a real issue when it comes to textualism and originalism and living constitution, which are all principles that are going to be discussed in this presentation. So, first things first, let's start with the lecture roadmap. In this lecture roadmap, we're going to have to start with the foundations for this presentation. We're going to go in the opening section, identify why constitutional interpretation matters and what makes judicial reasoning legitimate. Then we're going to move on to methods on how that applies. So the middle section of this, presentation will compare textualism, originalism, living constitutionalism, linguistic framing, and precedent and how those work. And then we're going to do a case study with respect to some of the final sections of this presentation. And that's essentially going to involve how these methods apply with respect to the 14th Amendment, Wong Kim Ark, and the modern birthright citizenship controversy. So moving on in the next section, some different topics as we're going to cover. Obviously, as I discussed, foundations, what constitutional interpretation is and why method matters for legitimacy. 2, we're going to discuss judicial review. We're going to go over a very famous Supreme Court case, Marbury v. Madison, and why courts claim authority to say what the law is. Then we're going to discuss number 3, which is competing methods. So we're going to go over textualism, originalism, living constitutionalism, structure, prudence, and precedent. And you're going to see that certain conservative justices have their leanings and certain perceived liberal justices also have their leanings. So I hope this episode is very informative and shows you what different justices believe with textualism, originalism, and living constitution. And then because I feel like I have a very strong linguistic background. I speak Spanish and Portuguese very well. Spanish pretty fluently, actually. Portuguese, very, very proficient. But I want to discuss how semantic framing, canons, and generally shifts in conversation can quietly move the outcomes of different judicial cases. And so we're going to discuss that with respect to the judges. Also, we're going to discuss the citizenship clause because we have to read that. We're going to see the 14th Amendment. We're going to see Wong Kim Ark and the modern birthright citizenship framework. And then we're going to do the modern stress test, which is Trump's order that federally directs not to recognize the legitimacy as United States citizens of children born on U.S. soil. There's some litigation that has gone on this year with respect to, President Trump doing that act. And so we're going to go over that, litigation just slightly or frame it correctly for you. And then we're going to, basically on the different disciplines we just study, originalism, textualism, and living constitutionalism, what we think should, work out and be applied. So, we have to start by obviously explaining what's the core problem. The Constitution is authoritative under American law. That's the highest law in American law is the Constitution. But judges still need a theory for how words should control hard cases. So what that essentially means is whenever you're reading a statute or whenever you're reading a different, case, Any of the words used in those statutes or cases are very important for later application because, later generations in theory and in practice are always going to reference the cases prior, which applied certain language. And they're going to obviously reference the source, which, as we see here, which is the Constitution as the most authoritative document in American law. So, what is constitutional interpretation? So, here's a problem when we're dealing with constitutional interpretation. Constitutional language is generally pretty old, it's broad, and it's often abstract. Judges still have to decide present disputes using things like, the First Amendment, for example. So they need a theory that links old text to new controversies. And so that's why we have disputes today on how the First Amendment should apply, the Second Amendment should apply. Hey, we haven't had any Third Amendment disputes come up in American law, none actually. Fourth Amendment, Fifth Amendment, Sixth Amendment. We could go on. This is what American law is. And then also the stakes with respect to constitutional interpretation. This fight's not only about who wins cases, it is also about what counts as legitimate legal reasoning rather than sheer political preference in judicial form. And what that means is essentially judges and independent, judicial thinkers, lawyers too, we want to have objective standards in order to decide cases. And we don't want to just be guided by certain political doctrines or political winds at that, because, obviously they're always changing with the different times and ages and generations. So we try to, bring up concepts like originalism, textualism, living constitutionalism in order to illustrate, how we can do this objectively. So obviously, I've got inserted some different questions for the audience, and if you have any, comments on how you would respond to them, please leave them. I would find them interesting. But what makes a constitutional decision an act of law rather than an exercise of raw political preference? And quite frankly, we have always had arguments on that very question, and we're likely still going to. So we have to go interpret what are the main sources judges invoke when they are interpreting and applying law. Well, one of the first things they're always going to do is reference the text. So, what the enacted language says and how reasonable readers would understand it. So, they're going to look at statutes, they're going to look at case law, and that text is very important. That's primary authority, which holds binding law. And then they're also going to look at history and structure. So, they're going to look at, at the time this text was passed, what did certain phrases or words, what were their meaning? So sometimes we have to look outside of the text in order to better understand the text. That's kind of the theory boiled down in that framing. So we have to look at the ratification era meaning, constitutional design, and the relation of one provision to the whole. Because sometimes, maybe a word is used a certain way in this part of the law, but in another part of the law, that exact same word is used this way, and it's structurally and fundamentally and understood differently. And then we also have to discuss precedent and consequences. So that's going to involve prior decisions, institutional reliance, and the real world effects of legal change. So, precedent is always very important for many reasons. It just creates a lot of stability in law, and we'll go over some of that. So, some of the questions that we have after this foundations topic and understanding the class is, try to get your mind thinking, what should dominate when we're interpreting and applying law? If it's the text, should it be the history? What if there's a precedential conflict, right? Which source should govern and why? What counts as legitimacy? Is a decision legitimate because it reaches the right answer or because it follows the right method? We also have, discussed maybe a different transition question, right? Which is how should constitutional authority, interpretive method, and the citizenship doctrine fit together in that analysis? So, very famous case we have to discuss on judicial foundations as well, and that's Marbury v. Madison, and that's very important for judicial review. That's why we have on the screen Marbury and judicial review. So before teaching how judges interpret the Constitution, we have to explain why courts claim the authority to do that in the first place. So what gives a court the authority to say, I'm the one that interprets this, not you, Mr. President, not you, Mr. Speaker of the House, or whoever leads the Senate, right? That's the theory. So the institutional starting point is this. The case background goes back to William Marbury, who he sought a writ of mandamus after his judicial commission was not delivered during the transition from Adams to Jefferson. And so really, just to clean that up and provide a little bit more factual detail with that, is William Marbury. Well, let me frame it this way. John Adams was the second president of the United States. John Adams had many political disagreements with Thomas Jefferson, who was elected to be the third president of the United States. So John Adams concocted a scheme where he, according to the Judicial Act of 1789, he was going to basically commission a new judge, a new court to decide cases. So rather than Article 3 courts, that come up in the Constitution, he's just going to create a court out of thin air, right? And say, well, this statute gave me the power to create this court, so here's the court. William Marbury is going to be the judge of this court, and I'm going to get basically the judge I want even after I leave the presidency. So very interesting political scheme concocted by John Adams in this situation, former President Adams, right? However, when President Jefferson became the president, he just flat out did not deliver the papers in order to establish that commission. So he didn't recognize William Marbury as having any judicial authority. He said, I'm not going to deliver the papers to give you this authority, so you have no court in America. And obviously William Marbury was not fond of that result. He sued in court, and that's why he brought this writ of mandamus, which is essentially a writ of mandate. So he was going to have the court mandate a particular action with respect to President Jefferson, Thomas Jefferson, delivering the papers in order so that William Marbury can become the judge of this court that was created by the outgoing president, President Adams. However, it did not work out that way. Chief Justice John Marshall, who is a very famous justice at the very beginning of the United States, in Marbury v. Madison, this very famous case, he held that the statute authorizing relief in that posture was unconstitutional and refused to grant the writ. And so what that means is this: even though William Marbury went to the court to say, look, President Adams wrote me this commission, and I should have the right to be taking this judgeship that this court created, the court said, yes, actually, according to the law in 1789, the Judicial Act 1789, that court was, validly formed under that statute, and you followed the correct process, and we're going to become the judge of this newly created court. However, this court conflicts with the Constitution. And ultimately, we are the arbiters, the Supreme Court of the United States, on what the final say on the law is. And we hereby decide that the Judicial Act of 1789 is, quite frankly, that provision void. And we have independent judicial authority and final judicial authority. So that's kind of the background on this case. If you have any questions, please leave them. I would love to answer them. And this is why Marbury v. Madison matters. Marbury is treated as the canonical statement that courts may refuse to apply laws inconsistent with the Constitution. It also plays an institutional role. It links adjudication to constitutional supremacy by insisting courts must decide what law governs when legal authorities conflict. Also, there's another institutional implication. So once judicial review is established, the next question is by what method courts should exercise that power. So judicial review is not the same as unlimited supremacy. Marbury, by many legal scholars, is often simplified into the court made itself supreme. And you'll hear a lot of conservative-minded justices think that. However, it's not always just conservative-minded justices, because quite frankly, a lot of conservative-minded justices very well back Marbury v. Madison. So don't want to condemn them on that or anything. But a more careful teaching point is that the case established judicial review in cases before the Supreme Court of the United States, while later debates ask whether that also means the judiciary is always the final interpreter for everyone in every contest. So we got a question here at the bottom. If you would like to provide your thoughts, I would love to hear it. But does judicial review necessarily imply judicial supremacy over all other constitutional actors? And so, what that means is this: imagine the president makes an executive order, right? Or Congress passes a law and then it's signed by the president. Well, who gets to decide if that law, whether it's passed through an executive order or through the Congress signed by the president, as the Constitution, provides? Who gets to decide if that's unconstitutional? The Supreme Court. And so, if the Supreme Court essentially has the power to say, no, that's unconstitutional, no, that's unconstitutional, no, that's unconstitutional, that effectively gives them the final power. And is that final power the ultimate dispositive power? And hey, this is not a resolved question. We still have quasi legal, quasi political debates on that very question. And it's very interesting. So here's some of the main interpretive methods. So with judicial review established, as we discussed, the next issue is how judges claim to interpret constitutional and statutory language faithfully. So, what textualism claims to do? We're going to first discuss textualism. Textualism directs the interpreter to the enacted words in their ordinary meaning, meaning not to unenacted intentions or broad policy desires. And it has an appeal because it presents itself as a disciplining method, because it ties judicial reasoning to public language rather than private legislative psychology. And so, when we're dealing with textualism, what we're saying is this: imagine I'm a judge, right? And I say, I'm a judge that's textualist. And I'm going to show you videos too of Supreme Court justices saying exactly this. But they're going to say, I read the text of the Constitution, and therefore I am a textualist. And I would love to ask you, if anybody's watching, or would you consider you're a textualist? And we're going to see some videos soon. What originalism claims to do. So we've discussed textualism, so now we're transitioning to originalism. So originalism holds that the constitutional meaning is fixed at the time of the enactment. So the meaning of those words are fixed at the time they were enacted. Those words had meaning at the time they were enacted. That's kind of the phrase you have to always keep in mind when thinking of originalism. However, there's different variants, obviously, in originalism. There's internal disagreements that remain over original intent, original public meaning, and original expected application. And it also has a claim to legitimacy as well. It often argues that democratic legitimacy comes from adhering to ratified meaning rather than updating the text judicially. And we're going to also discuss the principal liberal alternative. So, a lot of our quote liberal justices get accused of living constitutionalism. And living constitutionalism is said to treat broad constitutional guarantees as capable of application in light of modern circumstances, modern dangers, and evolving understandings of liberty and equality. In its disciplined form, it treats text as fixated or fixed, but application as adaptive. In its undisciplined form, critics say it can become policy-driven constitutional updating. So what I want to do now is I want to show you a couple videos of justices and how they interpret themselves as either textualists, originalists, or living constitutionalists. And again, before you watch these videos, I want you to understand that generally conservative-minded justices or judges that are, identified that way often identify as having textualist or originalist beliefs, while, I don't know if liberal justices really say that they embrace living constitutionalism, but there is an element of that shows up when you're critiquing certain liberal justices because, inherently it seems like they tend to side that way. So let's just go ahead and show the videos so you guys get some background. Very famous. We're going to see a lot of Justice Antonin Scalia. We're going to see Justice Clarence Thomas, Amy Coney Barrett, and all of those are very conservative justices. Two are still on the Supreme Court, Justice Clarence Thomas and Justice Amy Coney Barrett. Antonin Scalia, unfortunately, he passed away a couple years ago, but he's had a lot of influence in United States jurisprudence, and he is very well known in conservative jurisprudence as well and has a ton of influence. And then moving on to the next one. And I mean, guys, Justice Scalia, it was incredibly famous. Let's continue to watch just to see what a textualist is, what an originalist is, and what a living constitutionalist is. So this is video time. We used to all love that in school. So think of it like that here.
It had when it was adopted by the Congress or by the people if it's a constitutional provision. I've been very much devoted to tech.
Whoops. Excuse me, guys. We obviously had an audio problem, so I went ahead and fixed that. But let's go ahead and continue on. Basically, we can re-watch a quick couple of these videos. You can fast forward in the video at this point or backtrack, whatever you need to do. But obviously, we just had a quick error with the audio problem. But what I had been illustrating was I was going to show you videos of different justices that are textualists, originalists, or living constitutionalists. And that's what I'm doing here. So the audio problem's been fixed. And let's go ahead and watch this video. The previous one, you could see the subtitles. He described what a textualist is. You can read that for yourself. And this is just a reiteration of that continuing.
Textualism, and to that branch of textualism that's called originalism. That is, you not only use the text, but you give the text the meaning it had when it was adopted by the Congress or by the people if it's a constitutional provision. I've been very much devoted to.
So very much a devotion to textualism. Now, here's going to be the transition to originalism.
Let's try to figure out the mindset of people back 200 years ago, right?
Well, it isn't the mindset. It's what did the words mean to the people who ratified the Bill of Rights or who ratified the Constitution?
As opposed to what people today think it means.
As opposed to what people today would like.
So again, it's read what the words meant at the time they were enacted, which is the definition of originalism. Now, moving on to, you're going to see Justice Amy Coney Barrett here speak on how textualism and originalism has very much inspired her own judicial philosophy. So watch this.
So originalism, for those who are unfamiliar, is the approach to the Constitution that maintains that the text should be interpreted as it would have been understood by those who ratified it at the time, or those who were informed observers at the time of the ratification of the text. And this isn't a new theory of constitutional interpretation. It's been with us since the beginning, but it didn't have a name. It wasn't a self-conscious approach, this idea of looking back to the founding generation and the state ratifying debates and Madison's notes of the convention and so forth. And it was really in the 1980s, and Justice Scalia was one of the leaders of this movement, that originalism became self-conscious and developed as a theory of interpretation rather than something that courts and judges just did. He wrote about it, he taught about it, he spoke about it, and he practiced it in his opinions. And it influenced me as a law clerk, but also as a law student reading his opinions. He used to say, he wrote a lot of dissents, and he used to say that he tried to make his dissents very interesting and readable because he wanted the law students to read them. So originalism.
So again, you could see she's very much inspired by originalism, which she credits to Justice Scalia. And Justice Scalia obviously has already stated that he adheres to textualism and originalism. So you see the conservative-minded justices embracing both textualism and originalism. That's just a very important point you have to understand when you're evaluating how judicial philosophies work. So let's move on to the next video. We have another one with Justice Scalia, again, reiterating his positions. Check it out.
I'm going to talk this evening about originalism. Originalism is a form of textualism. Textualism means you pay attention to the text. Originalism simply means the text bears the meaning that it had when it was adopted. It does not morph. It does not mean something different today from what it meant when either the Congress or the people adopted it. There's only one other thoroughgoing originalist on the court, and that's Justice Thomas. Some other justices are originalists, I don't know, fair weather originalists, I guess. And so it's such a minority view that, some people sometimes they ask Justice Scalia, when did you first become an originalist? I'm going to talk.
So at the time, obviously, he didn't work with Justice Amy Coney Barrett, so he only worked with Justice Thomas, and he said that Justice Thomas is the only other originalist. So that's just a interesting, perspective to say the least. Now, here's Justice Clarence Thomas, and we're going to hear what he has to say about originalism and textualism. So please watch.
I was in Waco, Texas, a few years ago, and a gentleman from the audience asked me about textualism and about originalism and what it meant. And I knew he wasn't a lawyer. He was in cowboy boots. It looked like he just came in off the range. And he's a very plain-spoken fellow. And I said to him, if you see a stop sign, what do you do? And he said, stop. I said, that makes you an originalist and a textualist. I truly think regular people are that way, that words have to mean things, that language has to communicate something, that it may get ambiguous or complicated at some level. But I think what we have done to regular people with all this sort of fancy footwork and double entendres and levels of generalities is to disenfranchise ordinary people. People like my grandparents. As my grandfather would say, son, that's a fast talking fellow from New York. I think we are obligated when we interpret the People's Constitution to make sense of it and to be plain spoken.
Now, as you can see from that video, I have some disagreements with how simple he describes textualism and originalism. I think the stop sign analogy, while humorous, I don't think it exactly illustrates some of the more difficult questions that can arise in law and the inherent conflict that arises between textualism and originalism that we're going to discuss a little bit later as we go through birthright citizenship. But for now, it's just very important that we understand the judicial philosophies that influence this and how it's understood on the modern court and how the modern court also sees the past, because you have to understand how the court today sees the decisions of the past, because that's what courts, quite frankly, are always doing. So now, and also before we continue that, I just wanted to point out, I think also the stop sign analogy is also a way to take a slight jab at the more liberal-minded justices, or as Justice Scalia would describe them, those fair-weather originalists, right? Like they're the pure originalist-minded judges, and those other ones aren't. So I'm not so sure that it's fair, because if you say, well, I'm not a textualist or an originalist, well, then you're basically saying, well, I don't think a stop sign means stop, right? And that makes you look dumb. And so that's the humorist illustrative point. So, but let me stop yapping. Go ahead and watch Justice Scalia. Tell me what you think.
See, did the good guy win? Did the bad guy win? And you're inclined to say if the good guy won, wonderful judges, and if the bad guy won, terrible judges. That's not true. Unless you believe that every statute ever written produces a sensible result. But the ideal rule for the honest judge is garbage in, garbage out. You are supposed to interpret the statutes reasonably, even if you don't agree with the result, because it's not up to you to decide what's garbage. You're going to see, did the good guy win, did the bad?
So, did the good guy win? Did the bad guy win? Garbage in, garbage out. Now, what we're going to see here is this is Justice Elena Kagan. She is a very famous Supreme Court justice herself on the Supreme Court, and she's also known as a liberal justice. That's just the public reputation she has. I'm not so sure I subscribe to that. Some people would say I'm biased. It is what it is. But here's how she kind of somewhat critiques originalism and textualism, and let's hear what she has to say.
And so the question becomes, how do we interpret those phrases, and how do we decide what those phrases mean? Now, the originalist position, it's there are different forms of originalism, and everything's very complicated. And I don't want to simplify too much, but in essence, the originalist position is we look at what those phrases meant at the time. So there it was, in the late 1860s, we look at what people thought it meant to have equal protection of the laws or to have due process of law. And those set of applications, if you will, are the applications that we should continue and nothing else. And both of them are seeming to pick and choose from the historical record, sort of to cherry pick. Justice Scalia called it picking out your friends in a crowd when he talked about legislative history. And so the question.
So as you can see, what she described about originalism, the way she critiqued it, as she said, it can be, quote, complicated. And, what she means by that is, again, earlier, as I described how originalism is, where it's basically looking outside of the text in order to understand the meaning of the text. So textualism focuses on looking only at the text, while originalism says to look outside of the text in order to understand the text. So it's like I can look at the text or I cannot look at the text. And I can really just do whatever I want, quite frankly. And I can take the position that I'm a textualist and I am an originalist. And so that's what it becomes, where it's like, look, this is kind of an unworkable system. It seems, quite frankly, arbitrary and capricious. Like, oh, I don't like what these words say. Let me just look outside those words. And oh my gosh, this originalist interpretation has given me this ability to interpret this phrase that way textually, right? And we're going to get more into that as we discuss the birthright citizenship. And so when you have that frame of mind and that critique on originalism and textualism and how they inherently somewhat conflict with each other, it then births a more, living constitutionalism. Now, again, Justice Kagan, I'm not so sure, is going to describe herself as embracing, quote, living constitutionalism. She would more likely embrace it as, reasonable judicial philosophy, for example, and just kind of, moving on with the times, right? Like you got the First Amendment. Okay, the First Amendment had its meaning when it was passed. And then, we go through the generation. And then, we got this 1960s and how people express themselves. And all right, now people express themselves in all kinds of political ways, right? So a lot of just controversy within it. All right, so let's go ahead and get back to our slides. So we've went ahead and discussed a little bit of textualism, originalism, and living constitutionalism. And as you saw, more of our conservative-minded justices, or how they're known per their reputation, they embrace textualism and originalism more often, while more of our liberal-minded justices, per their reputation, embrace what's called living constitutionalism and critique originalism and textualism as having inherent conflicts and, quite frankly, being complicated. And I somewhat subscribe to that view. So maybe if I ever am in front of the Senate being confirmed to the United States Supreme Court, they would be like, Nick, why are you a liberal justice? And I would just say, look, I just think textualism and originalism, as much as we try to apply it, and hey, I love language. I'm always, and I believe in textualism and originalism, quite frankly, but there are developments within the law that make that difficult, as we'll illustrate in our further example. And also, I challenge you, as any viewers that would like to get more specific on some of those general topics that I've described. How would you think that one could use originalism to essentially see the text differently than from what the text actually says, right? That's the critique of that dual philosophy. So, interesting slide we got here. We got a little bit of structure, which is some arguments infer meaning from constitutional design rather than any single clause in isolation. And so what that means is, like, if we use the term liberty in phrase A, if we then use freedom in phrase B, does freedom and liberty have the same meaning? Well, I guess they kind of do. There is a huge overlap, right? But why did the creators of the law use two different terms? Why did they use liberty here and why did they use freedom here? And so that's also the studying of different words and how they're used in statutes, and what gives them, quite frankly, different structures. Oh, 1 second. Let me just adjust something on my computer. All right, back to it. So prudence is some judges weigh institutional consequences, administrability, and the costs of destabilizing law, which jumps into like, if you overturn law of the past, right, it can have, some consequences, especially, with respect to how do lower courts now interpret the new law. Why was it overturned? Does that then provide openings that lower courts can say, oh, well, they overturned it in this context. Let me then overturn it in another context. And that, quite frankly, happens more than one might think on its surface. And then we also have to discuss precedent, which is no serious modern court decides only from scratch. They're always looking to past cases. Precedent mediates every grand theory. So again, the idea of precedent is this. In order to decide the case before us, let's look at similar cases that have, in the past that can guide us on how to decide this case. And generally, courts are going to adhere to how cases were decided in the past in order to create stability within the law. So, questions after the methods overview. Which method sounds most constraining? Textualism, originalism, or living constitutionalism? As I've kind of mentioned, I think it's a difficult task to say. I think quite frankly, living constitutionalism is not very constraining, but that's a danger. And then the combined textualism, originalism, inherent conflict, being able to use originalism to violate the text, that's also, conflicting as well and can not lack constraint. So I think both could be lacking constraint. Which method is most vulnerable to selection effects? Where can a judge most easily smuggle in preferences while claiming neutrality? And here's a transition question. Which interpretive problem most sharply tests judicial neutrality? So let's go ahead and move on to the next. What I would like to discuss is how language can be manipulated. So this is basically going to be a bridge from abstract method to practical abuse that judges can take when applying the law. Outcomes can move through framing choices while the judge still claims to be following neutral language. So linguistic manipulation is often invisible. It's difficult to detect. Just by the way one is speaking to you, they can essentially be engaging in a form of linguistic manipulation. And so you always have to consciously be aware of these different types of framing. But a court does not need to openly reject text in order to redirect a case. It can instead redefine context, choose a narrower or broader semantic frame, announce plain meaning too quickly, or pick one canon of interpretation while ignoring another. The result is that linguistic argument can appear neutral even when it is doing heavy normative work. And so again, what that means is, I can look at this, text and I can say, oh, well, at the time of, it was written, it actually means this because I'm looking at this document that the author of the legislation wrote, and in this document he meant this form of that word, and so that's why this word, even though seemingly has this meaning A, it actually has meaning B. And that's actually where we start getting into forms of linguistic manipulation and what are proper sources of reference and how do we vet those sources in order to properly analyze them when we're interpreting law of the past and applying it to future cases before us and future cases. So the linguistic toolkit of selectivity. There's all kinds of, there's 5 we have on screen, but there's a general shift or generality shift. So we can describe the principle narrowly to deny protection or describe it broadly to grant it. So if I say we're talking about granting due process rights, with respect to criminal protections or any type of, constitutional rights you see. How narrowly can I interpret that? Or do I want to say, no, actually, there's like the 14th Amendment provides for different anti-discrimination laws. And when typically these types of anti-discrimination laws come up, you have to identify the class of individual that's being claimed to be discriminated against. And so when we're dealing with this generality shift, sometimes it's a matter of, okay, do we fit this class as having this constitutional protection, or can we extend it one branch further and have this class actually protected by this? And some people would say, no, that class was not recognized at the time of the text. That class is a modern, whatever development that's now trying to claim rights that were actually belonging to these classes of people in the past. And so that's what a lot of the conservative-minded justices' critique of the liberal ones is, that they're trying to broadly grant rights of the past to different modern classes or groups, and that they shouldn't be doing that. And then on the inverse, sometimes certain conservative-minded justices can be critiqued for doing the opposite, which is seeing language, and the language seemingly is more universal, but they constrain it to a point that it seemingly, conflicts with the text right in front of you, because they're like, well, I looked outside of the text, even though I'm a textualist, and because I'm also a originalist, so I'm looking outside the text to get the meaning of the text, even though the text says this. So, there's all kinds of conflicts in that. We also have what's called dictionary shopping. So we can choose the broad or narrow definition that best fits the desired result. And I just want to go ahead and get through some of these. We have false plainness. We can declare ambiguity gone before history, structure, or rival readings have really been confronted. We have canon selection. We can treat one interpretive canon as neutral while ignoring competing canons pulling the other way. We can have context reframing, which is change the linguistic setting so the same phrase appears to do different work. And then the practical effect is a court can say, we are only reading the words, we're only reading the text, while actually performing hidden value choices. So, they can look back at the text and say, oh man, we don't actually want it to be applied that way, but we can't say that. So you know what? We'll just say at the time when they wrote that text, they actually meant this over here. And so that's why today that text, even though it says that, and it, most people think it applies like that here, it actually applies this way. And a lot of people just don't subscribe to that. They feel like it's anti-democratic. And we're going to, jump into some of those principles as well. So moving on, excuse me. So this is where method becomes rhetoric. So here's the surface claim. The judge says, I'm simply applying language as written. I am simply applying the text. I mean, you saw the way Justice Clarence Thomas framed it, right? I am just applying, when I see a stop sign, I'm a textualist and I'm an originalist. So I'm a textualist and originalist too. I stop at stop signs and red lights. And, interestingly enough, that's symbolism, I suppose. So we have some underlying, reality we have to address as well. The operative work may actually come from framing, classification, and hidden assumptions about what the contested words are allowed to mean. So as I described, the way you frame the different text, classify classes within the text, or assume certain meanings of the text, that all has impact on textualism, originalism, and somewhat living constitutionalism. So the critical questions are, why this definition? Why this frame? And why call the text plain at this point? So method, conflict, and stare decisis. The methods are often marketed as harmonious but difficult cases expose real conflicts between text, history, and precedent. And so what we're going to do is we're going to jump into stare decisis. Let's see. Okay, but I don't know if we have a definition, so I'm going to just say what stare decisis is. Stare decisis is a Latin term for to stand with what is decided. Stare means to stand, and decisis to means things that are decided. So literally those words together, stare decisis, to stand with things that are decided. And courts, value stare decisis because to, stand with things that are decided is essentially what creates what we know today as precedent, and to follow past precedent. And so whenever we say precedent, we're inherently somewhat referring to stare decisis. That value comes from Latin. So why these methods can diverge, textualism and originalism. So the textualist focus is what the enacted words would reasonably communicate in legal context. The originalist focus is what the provision meant or was understood to entail at the time of ratification. A judge can blend them honestly, but the danger is sliding from one to the other only when one path produces the preferred result. And so what we mean by that is this. Imagine I'm a judge, right? Any case before me, and you do your own mental exercise and, jump into how I'm framing this and put on your thinking cap, right? So you're a judge, you have a case before you, and according to the text, you could decide, decision A or decision B. You personally want decision A. You don't want decision B. Decision B has been presented to you by the other attorneys, and things of that nature. But the other party, obviously, they want decision A. You also want decision A because that fits your value system or your religious beliefs or any type of political interest, social interest you have, personal interest. And so economic interest, you name it, legal interest. And so essentially with decision A, you say, look, this fits me better. So in order to justify decision A, I am going to focus on the text of the law, which gives me more authority to decide this way. And so, however, let's think of the other way, right? So let's say, the text doesn't fit what you want, but you need decision A, right? Well, let's go ahead and say to the parties before us, look, I know the text says this. However, let's look at the past and the way this word was used at the time the language was enacted. Aha, here is document A, document B, diary entry from my cousin C. I mean, and this is quite frankly some of the ridiculous stuff. People start referencing diary entries and letters and, not even official documents, but what they're trying, and judges do this, and lawyers and judges, they'll be referencing just, letters written by certain politicians or other judges because they were involved in the enactment, right? And so that's where you can essentially have, like a sliding scale, right? So I need decision A. I don't want to decide decision B. All right. So in order to get to decision A, is the text on my side? No. Okay. Then we're going to emphasize different context and why the text actually seemingly is wrong in this situation. However, all right, other situation, the text fits what I want. You know what? Let's go with the text. Text says this, we're deciding that. And so that's essentially how those methods diverge. Precedent is the stress point. Why does precedent exist? Precedent promotes stability, reliance, and the equal treatment of like cases. That's why you always hear somebody say, we have precedent for this. What about precedent? I'm sure all of you have heard that term. Why it bothers legal theorists or philosophical theorists in general. A precedent can be deeply entrenched even if a method purist believes it was wrong from the start. And so one of the issues with precedent is essentially the belief that, well, cases in the past were decided wrongfully. And so you see the inherent conflict where there's the value of stare decisis, but there's also the value of overturning cases that were, quote, wrong from the start. And you can see the inherent conflict meeting each other, right? Again, I don't know how it can work where you need to promote stability and do cases like they were in the past, and that's your value, but then you also have a competing value that says, no, even though that case was decided like this in the past, I don't think that was right, and so I'm going to override stare decisis. This is what it reveals. The treatment of precedent often exposes whether a method is genuinely constraining or only selectively constraining. So, how theories can undermine their own values. So, for the conservative tension, originalism can erode textual constraint or legal stability when it privileges expected applications over enacted language or treats precedent as disposable. The liberal tension is that living constitutionalism can erode democracy and predictability when evolving values outrun text, structure, and settled limits. And I'm sure each of our viewers can likely think up different scenarios where they see the conservative examples and the liberal ones. But before we get to those questions, I just want to show you some quick videos on stare decisis and what some judges think. So here we go. We got Justice Clarence Thomas here.
Do you see originalism and stare decisis as in tension with each other? And what factors do you bring when you write an opinion that suggests maybe a line of cases should be revisited?
Well, if I find it doesn't make any sense, I think we should demand that no matter what the case is, that it has more than just a simple theoretical basis. You know, I remember when I took constitutional law in law school. It was a small group, and my professor was Thomas Emerson, who was fondly known by the law students as Tommy the Commie. But he was he was one of the lawyers who argued, and I think he argued before the Supreme Court, Griswold versus Connecticut. And a lot of that came out of Yale Law School and Yale Medical School and Connecticut, Eisenstadt, and some of these other cases. I remember him ridiculing Griswold, even though he agreed with the bottom line, with the result. And he would just make fun of it. And I said, well, why would something that he considers totally ridiculous be something that you don't revisit? And I mind you now, I was to the left of Karl Marx at the time, ideologically. But I didn't understand how someone could take seriously something he's ridiculing.
Before we continue, so yeah, kind of two, interesting things to take from that. First, I think it's interesting for Justice Clarence Thomas to say that he was left of Karl Marx, because Karl Marx is obviously the founder of communism and wrote the Communist Manifesto, and quite frankly is famous in history for that. So I never knew that about, Justice Thomas actually prior to having seen that video. However, one of the things that I'm sure you saw at the beginning of that video was Justice Thomas, when they asked him how, do you feel like originalism and, originalism and what were we talking about? Oh, stare decisis. Do you feel like originalism and stare decisis are inherently in conflict with each other? And essentially, he said, well, when I feel like it, and that's seemingly arbitrary. I thought the way it came off was, well, when I feel like it. And just to illustrate another example of when that actually does occur, I just want to bring on Amy Coney Barrett to provide her own thoughts too.
This is probably the most controversial case the court has decided where it has overruled precedent during your tenure on the court. 2022 abortion case, Dobbs versus Jackson Women's Health Organization. And in Dobbs, this court overruled Roe versus Wade of 1973 and Planned Parenthood versus Casey of 1992. Take Roe, which had stood for 49 years. Explain why that was an exception to stare decisis.
The point of stare decisis is to create some stability in the law, so that it's not a new day every day, that people can rely on it. So a case can't just be wrong, or it can't just be wrong in the opinion of Amy Barrett, but if it's egregiously wrong in ways that have left the law unsettled or have had other bad consequences, they're not off limits in stare decisis. One thing about Roe, even by legal scholars who were themselves pro-choice,
Justice Ginsburg
thought that Roe had moved too far, too fast. John Hart Ely, who Justice Alito quotes as an opinion, was a famous constitutional law scholar, a pro-choice scholar, wrote criticizing Roe at the time as just having no basis in the Constitution. So I think Roe was widely regarded as an ill-reasoned decision, and it just came up with this trimester framework. I mean, where was that in the Constitution? And it was very, very hard to defend from the perspective of any kind of constitutional theory. And as Justice Ginsburg's saying it went too far, too fast highlights, Roe was way ahead of where the country was in abortion at the time, too. And in Casey, a plurality of Justice Kennedy, Justice Souter, and Justice O'Connor declines to overrule Roe. They never said Roe was right. They never said Roe was rightly decided. The plurality opinion was about stare decisis. And in that plurality opinion, there is a passage that says it's time to just treat this as settled and call the, contending sides of this national controversy together to end this division. And I think that at the time, what the plurality thought when it declined to overruling Casey was that Roe was wrong. It was wrongly decided. It was poorly reasoned. However, it was a precedent, and it was just going to cause upheaval to overrule it. And that if the court said we're not going to overrule Roe, then the temperature would come down on the abortion debate. But that didn't happen.
So, as you can see from that, Justice Barrett, she goes on to point out that, how do you decide, when stare decisis should, not apply, and that you should depart from precedent? How do you know when to overrule past cases? And, Justice Barrett essentially says, well, when they're, quote, egregiously wrong. Now, egregiously wrong, if I got a discovery response with that type of description, I would object as vague and ambiguous. That just naturally is going to implicate those words. And she goes on to describe, well, why was it egregiously wrong? Because that was speaking in the context of overturning Roe. She says, well, Justice, Ginsburg used that it moved too far, too fast. And so that's why justices are always watching their language and how they speak. And generally, while judges are always policing their own language and how they talk publicly. So, I think when you have, Justice Clarence Thomas, and he just says, well, when do you know stare decisis and originalism are in conflict? When do you know you should overturn precedent? He says, well, when I don't like it, right? That's kind of how he framed it. And then Justice Barrett says, well, when it's egregiously wrong. Now, again, is there an objective standard for this? I'm not so sure. I do think there's some subjective belief in that. I think these are two conservative justices, but who's to say a liberal justice can't say, you know what? I'm just going to overturn previous precedent because, it just doesn't sit right with me. I feel like it. And, it's egregiously wrong. And, they'll point to certain other language, maybe not too far, too fast, but we'll just point to some other, kind of vague quote, right? And just overturn precedent, which historically, creates stability. So that is an illustration of why stare decisis, even though it is a value for both, conservative and liberal justices, you will see conservative and liberal justices depart from stare decisis. And it's more of this competing ideology with each other. Each side wants to claim, well, you were wrong from the start. No, you were wrong from the start. No, I understand. I have the original. No, I have it. And it's just this internal, judicial debate with each other that, quite frankly, has been going on since the founding of the country. And so what I want to move on to is you're going to hear in this video, Justice Roberts essentially compare how he's the Chief Justice. So we're going to say the Roberts Court, and he's been the Chief Justice, I think since 2005. He was appointed by or nominated by President George W. Bush. And so we say the Roberts Court. And so when we're dealing with, when he says the Warren Court, he's saying when Chief Justice Warren was the Supreme Court Chief Justice. And he right here is saying that, look, we don't overturn cases like courts before us. So to critique us as, not valuing stare decisis, or to critique us as being judicially active, that's wrong. And quite frankly, I want you to watch this video. Tell me what you think on, how he presents it. And then I'm going to give actually my critique on it.
Warren Court, I think, overruled an average of 3.2 cases a year. The Berger Court, maybe surprisingly or not, an average of 3.4. The Rehnquist Court was significantly lower at 2.4, per year. The last I looked, the current court's average was 1.8. So the perspective of how many cases are being overruled and all that, I think people have a misunderstanding about how much the current court is overruling precedent.
So interesting, take by Justice Roberts, and very much appreciated for him to compare, what he describes as being overruled in the past. However, my only critique of Justice Roberts presenting it this way is this: what is his definition of overruled? Because I'm sure that, let's say a single ruling, right, can overrule multiple cases of the past. Imagine, a court, tomorrow made a ruling that suddenly upends all kinds of laws in the past. Well, does that count as overruling one time, or does that count as overruling, 100, times? So how do we calculate that? So that would be a bit of my question. And what I would delve into is I would say, well, can you explain your definition of, how you came to, how did this court, overrule them? What's your definition of overruling? How could you explain that definition? Because the way I see it is sometimes you don't have to just say, I overrule this, right? You could write language on the side that could then be justified later as maybe overruling, another. And it's because we're always reaching to what did this court say on the law and how does that apply to future cases? So that would be my critique, is essentially, hey, what's your definition of overruling? How did you come to that? I mean, that sounds quite frankly quite low for any of those courts. I thought they overruled many more cases than just 3.4. I mean, oh my gosh, the Warren Court overruled like all kinds of precedent in the past. They came up with all kinds of due process precedent, especially in the criminal constitutional rights context, such as the Miranda rights and things like that. And so I'm very skeptical of that claim and comparison of overruling in comparison to previous courts. So let's go ahead and get back on track with our, slides. And unfortunately, with no more videos, but we got a really good store because we're about to do some really good comparison. So let's go ahead and go through some questions after this conflict session. So what should happen to bad precedent? Should it be overruled? Should it be narrowed? Should we preserve it for stability? So stare decisis. Which side is more selective? Or is the selectivity the shared pathology of all high-level theory? So would you say that liberal justices are more selective or conservative justices are more selective? And if so, why do you say that? I would want to know, quite frankly, because I've given you, I think, enough evidence to show, how each side could, be critiqued, quite frankly. And the next question that's going to naturally arise is, how does this conflict appear in the law of citizenship? And that's what we're going to be transitioning to. So we have the 14th Amendment and birthright citizenship. So let's go ahead and apply the methodological debate to a case study where text, common law, history, precedent, and politics all converge. So, first thing I want to do is put on screen the citizenship clause. The citizenship clause provides this: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So, for a textualist, right? Let's go ahead and read this again. Let's be textualists. I want to practice textualism. That's what we're doing here. That's why I got it in quotes. There's the text. Read the text. Focus on the text. You see my point. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So let's go ahead and dive into the textual issue. What does subject to the jurisdiction thereof mean in legal context? And there's also an interpretive issue. How much narrowing can a court do before it is rewriting the clause rather than interpreting it? So why common law ideas matter here? And what we mean when we say common law ideas is, why does precedent matter here? Because again, we generally, if you're a judge, right? Imagine if I want everybody to put on their old little white curler, wigs that all the judges in the 1700s, wore. And I want you to ask yourself, if you're a judge, okay, you get a case before you. How do you decide it? Do you decide it on your own personal values? No, you can't. You have to look to the law. Okay, let's go ahead and look to the law. Well, how's this law been applied? So we have the text, right? We have the statute, but now we have to see, how has that statute been applied by the courts? How do the courts understand that statute? And so that's what we mean when we're getting into common law ideas and precedent. It's how courts reference, statutes and how they look at previous courts that have decided those statutes. So we have to understand Wong Kim Ark, which is a case that I'm going to bring up. So Understanding Wong Kim Ark requires some background on Judicial and allegiance. The later case did not emerge from nowhere. It relied heavily on an inherited common law tradition under which birth within sovereign territory generally conferred membership, subject to narrow exceptions such as children of diplomats. So let's go ahead and move on. So, Wong Kim Ark. Here are the facts of the case. Wong Kim Ark was born in San Francisco to Chinese parents residing in the United States and was denied re-entry on the theory he was not a citizen. So Wong Kim Ark, born in the United States in San Francisco of Chinese parents, because quite frankly, in the past history of the United States, we had a lot of Chinese immigration in order to develop infrastructure, especially in the western part of the United States. So that's, Wong Kim Ark's ancestral history, family history. Well, his family had brought him back to China just to visit, and he comes back to the United States thinking, hey, I'm going to go home, going to go be at the Bay in San Francisco, and he's denied re-entry. And basically they say, you're not a citizen, so we're not going to permit you re-entry. He sued, and he went all the way up to the Supreme Court, and the Supreme Court held this. The court held that a person born in the United States to non-diplomatic parents residing here was a citizen under the 14th Amendment. And here's the force of the decision. The decision became the canonical precedent for modern birthright citizenship doctrine. And so what that means is this. This case was decided in, I believe, 1896. So we had, the citizen, let's go back here to the citizenship clause. This was passed. You know what? I got a timeline here. So we have a short timeline of this settlement. So go ahead and look on your screen. In 1868, the 14th Amendment constitutionalizes national citizenship. So we just get through a civil war. We see what occurred. We freed the slaves. The slaves have been born in the United States, right? And that's why you hear President Trump say that 14th Amendment only applies to the children of slaves. That's his legal theory with what this 14th Amendment means and why it was written that way. So the 14th Amendment constitutionalizes national citizenship, and it effectively grants citizenship to all persons born in the United States and subject to the jurisdiction thereof. In 1898, Wong Kim Ark supplies the definitive Supreme Court interpretation of the birthright principle. So you have essentially 32 years after the 14th Amendment is passed, a court says, no, this is the factual scenario that occurred. Wong Kim Ark, born of Chinese immigrant parents, leaves, and by the fact he was born in the United States on U.S. soil, jus soli, he is a United States citizen. So let's go ahead and say why this case is so important. The substantive effect is this. The decision strongly confirmed that birth on U.S. soil ordinarily confers citizenship, even where the parents are not themselves eligible for naturalization. Here's the methodological effect. The opinion intertwined constitutional text, common law history, and a broad conception of territorial jurisdiction, making it especially hard to dislodge without confronting precedent directly. And so what that means is this: where the court in 1896 stated that we hereby interpret the law of the 14th Amendment as passed in the year of our Lord 1868, right? This law means that anybody born in the United States is a citizen. That's the law. And what stare decisis say, as we previously discussed? Stare decisis says judges should apply the law that previously was decided, right? And so what Wong Kim Ark does is this. It births the birthright citizenship right, that if you're born in the United States, you are a citizen. And from here on, the future, for any future, law applied, that you have to actually, if you're born in the U.S., you're a citizen. And also, we're not going to get too much into it, but when you look at some of the 14th Amendment text, there was actually a congressional law passed, which is a federal statute, so not a constitutional amendment. So a constitutional amendment and a federal statute passed in Congress are different. And Congress had tried to pass a federal statute, and they did pass it, that, basically held this exact thing, that if you're born on U.S. soil, you are a citizen. What happened, the Supreme Court either overturned that, or the Supreme, or actually the Congress decided to have the amendment in order to make sure that the Supreme Court has to apply that, the language they see it, that the Supreme Court can't just escape it. And because look, you got the Constitution and then you got federal statutes. Constitutional provisions are always higher than federal statutes. So we have to always abide by the Constitution. And so Congress thought, okay, well, we have a federal statute that codifies birthright citizenship, but let's go ahead and remove this from the power of the courts to, or interpret it oddly. Let's go ahead and not let the president apply it wrongfully. We're going to not just make it a federal statute. We're going to actually make it a constitutional amendment. And that's exactly what they did in the 14th Amendment. And again, before we continue, I got to reiterate this. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Wong Kim Ark said that provision. So according to the text and, and they engage in originalism, and, you have to respect stare decisis, right? Birthright citizenship is a law. President Trump and his legal theory now contest that and subject to the jurisdiction thereof phrasing. So going back to this timeline, so we have 1868, 14th Amendment passed. 1898, Wong Kim Ark supplies the definitive Supreme Court interpretation of the birthright principle. And then in the 20th century, the doctrine is reinforced through public law, administrative practice, and general legal understanding. And so what that means is this. All the lawyers throughout the 20th century understood, hey, after Wong Kim Ark, this is the law. The Supreme Court said that's the law. We now have to follow that law because stare decisis says we got to follow that law, right? And also, too, Wong Kim Ark was reinforced. It's not like Wong Kim Ark was decided in 1896 and then, 1898, and nothing thereafter, ever involved these similar types of facts. What actually happened is further cases like this did arise. They all looked to Wong Kim Ark, and they kept deciding on Wong Kim Ark. So it's like a tree branch, right? Or a little seed where Wong Kim Ark's the seed, and then little branches start breaking off. And that's essentially how this jurisprudence developed. And there was a general legal understanding of that. Lawyers at law school were taught this. This is the law. This is the way it's interpreted. And then, with President Trump coming back to power, he opened some modern litigation that essentially says he passed an executive order that directs all federal agencies not to recognize children born in the United States, but, their parents aren't citizens, as having citizenship. So he effectively confronts Wong Kim Ark directly, doctrinally at that as well. And so that reopens questions that many lawyers treated as settled. So as we just discussed, Trump's executive order and the new litigation, this is the modern case study where every interpretive tension becomes immediate, visible, and politically consequential. And what the order tries to do, it targeted children. The order seeks to deny recognition of citizenship at birth to certain U.S.-born children based on the parents' immigration status. Here's the constitutional theory. Its core claim is that some U.S.-born children are not subject to the jurisdiction of the United States within the meaning of the 14th Amendment. The order turns the whole course into one dispute. So the text, can the government plausibly read the citizenship clause narrowly without distorting its language? Here's the history. Do historical understandings of allegiance and jurisdiction support the narrowing argument? So we have the textualism approach there in the text, the history, which is more so focused on that originalism, approach, and then we have precedent. So can Wong Kim Ark, which is precedent that's been developed, be limited without being functionally overruled? And so that becomes the question. Is, a lot of living constitutionalists or maybe liberal justices would emphasize stare decisis. You must look the precedent. You must apply the precedent. And maybe some, I don't want to say all conservative justices have this opinion, because I actually anticipate that, the Supreme Court will actually not side with Trump on this issue. I think the Supreme Court will continue Wong Kim Ark. That's my own professional opinion on how the Supreme Court would decide that. And the Supreme Court is definitely going to look to the text. They're going to see that the text includes, all persons born within the United States, right? They're also going to look to the history And a lot of those historical understandings were engaged by previous courts that applied the cases. So the court's going to look, hey, what did these previous courts say about the historical understandings? Let's go ahead and take their input and apply it in that sense. And then precedent, as we've seen with the way Justice Amy Coney Barrett described it, to have stare decisis creates stability within the law, and that's very much a value that we seek to have. So this is not only a citizenship dispute. The controversy is really about judicial method and institutional legitimacy. It asks whether courts will follow text as written, history as carefully understood, precedent as inherited, and constitutional amendment rules as binding, or whether interpretive vocabulary can be used to reclassify settled law without admitting it. So let's go ahead and look at the liberal mirror and give our final thesis. So we want to keep the course fair and conceptually honest. It should, show that this selective method is not really a one-sided problem. So we do have, some liberal doctrinal problems with trying to just say, hey, conservatives are messing up everything through textualism and originalism. Well, that's not always the case. So here's what liberal justices can do analogously. Now, they might not say they're doing this, but this is what objective observers are saying they're exactly doing. So, some people just don't admit their flaws, right? That's an unfortunate part of being a human. Here's the methodological, I can't even pronounce that word, guys. Excuse me, I got to practice a little bit more. A liberal court can invoke dignity, equality, or evolving values to expand rights, even where text and history provide only weak direct support. So again, I'm sure you guys have heard that before, maybe have critiques of certain liberal mindsets or worldviews where, they're trying to invoke dignity, equality, all these evolving values and expand rights that never applied to these groups. As I discussed earlier in the video, they essentially come up with these different classes of individuals and say, well, these different classes deserve dignity and equality like other previously recognized classes. And that's more of how liberal justices can be critiqued and how they, develop their own opinions. Here's the trade-off. That can advance rights while also weakening claims to democratic accountability and predictability if method becomes too openly result-oriented. So the question is this. So in our history, especially in the United States in the mid-20th century, we had a lot of rights that were developed through jurisprudential development. So, like I said earlier, we had Brown v. Board of Education, right? That integrated schools all across the United States. And, that wasn't really the Supreme Court doing that. The Congress was a little bit too not getting that done, that the Supreme Court said, look, we actually see this as violating constitutional values and we're going to upend. So they got rid of, upended stare decisis, got rid of Plessy v. Ferguson. And so that's maybe a good example of where liberal justices are remembered positively for doing acts such as the integration of schools, right? And again, that was like a living constitution thing because you had to overturn precedent of the past, Plessy v. Ferguson, maybe that Justice Amy Coney Barrett would describe as egregiously wrong. So selective method is the common danger. Conservatives can invoke originalism in ways that undercut text or precedent. Liberals can invoke living constitutionalism in ways that undercut democracy or legal stability. The unifying problem is not one ideology. It is the use of interpretive theory as an after-the-fact explanation for a result already chosen. And so what that means is this, and we have to be very honest with ourselves. I'm a human being. I have values. I don't want to see, like, for example, let's say some politician rises up and says, you know what? I'm very anti-crime. I'm going to impose wild punishments. We're going to start, I don't know, throwing people off buildings, right? Like, let's say he comes up with that. I'm going to say, whoa, whoa, whoa. This is a violation of the 8th Amendment. And he's going to say, no, this is fine. Or, some conservatives go down the rabbit hole with defending, like, almost awful punishments and not saying it violates the 8th Amendment. That's just my opinion. But yeah, I think you have to always be mindful that, like, okay, what if you're conservative, if you're liberal, what's the goal you want? Are you do you want like a certain result to come out of this case? And if you do, what mental gymnastics are you going to take to get there? Are you going to try to say, well, even though the text says this, I'm going to look at what the text meant at the time it was enacted, and well, here it actually meant this, even though we understand today it means this. And you see a lot of like that show up, not only in like legal jurisprudence and law, but you see it quite frankly show up even in like religious debates too, on how certain religious authorities should be interpreted and applied later. And the value they have. Here's some questions for further analysis and almost provide for a final discussion. So can method ever truly constrain judges? Again, can method ever truly constrain judges? Or are interpretive methods or interpretive theories mainly stylized vocabularies of justification? So are we going to be so cynical that, let's just say there is no objective theory a judge can use. This is not 2 + 2 = 4, 2 × 2 = 4, 3 + 3 = 6, 4 divided by 2 = 2. It's not like that. It's not balls and strikes so easy. You're going to bring an element of your own worldview, your own viewpoint. Whenever you hear, let's say you're a conservative person and you very much value religious rights, right? And you hear of an athletic coach at a public program, at a public high school, professing his faith with his team and encouraging the team prayer, you may see that as a form of First Amendment protection, and and it doesn't violate anybody's rights. However, you might not see it that way. And then two, we could discuss other political issues, right? Gun rights, anything. I mean, anything, guys. You use it. You think of it the way you would think of it. What should the audience watch for? Definition choice. Again, whenever we're engaging in certain discussions like this, always try to see what definitions are people using. So when somebody says, well, this causes happiness. Okay, what's happiness? Can you define it for me? Not be vague. Always look at definitions. Try to make them specific, not ambiguous. And again, that kind of leads into the level of generality. How general are they being? Are they being specific? How do we handle precedent? Are we adhering to precedent? Do we break from precedent because, we want to, or we find it egregiously wrong in the past, such as Justice Amy Coney Barrett did with Roe v. Wade, or the way the Warren Court did with Plessy v. Ferguson, which, was separate but unequal practices. They called it separate but equal, but it was separate but unequals, what the Warren Court said. And then sudden declarations of plain meaning. You'll see a lot of, judges, as we've said, just say, hey, that's the plain meaning. Nobody questioned that. What are you questioning that for? Oh my God, you're crazy. That's kind of the way they'll just declare. No, you can't question. Oh my God, no, that's the plainly meaning. And it's like, well, let's look to the past and see what its meaning was. Tough. It's tough. Final question. Which of these issues most directly tests whether interpretive theory genuinely constrains judges? Is it textualism? Is it originalism? Is it living constitutionalism? And that's going to be, most of what we got. Here's our central takeaway. Taken together, these materials show how judicial review, interpretive theory, precedent, and citizenship doctrine can converge in a single constitutional controversy. The larger lesson is that interpretive method matters most when it is tested by hard cases with real institutional consequences, which is definitely this case involving, citizenship, because, whenever we're dealing with, citizenship, it's going to implement a lot of moral causes and what should the law be in light of Wong Kim Ark. And I guess one takeaway question that I would have for all of you as viewers: what do you think judges should apply? Originalism, textualism, living constitutionalism? Do you think textualism and originalism are inherently in conflict? What are your flaws of living constitutionalism? Do you think liberal judges also use textualism and originalism, or is that only conservative justices? And vice versa. Do you think conservative justices engage in living constitutionalism more, or liberal justices? So anyway, That's going to be all for this episode. Thank you for coming. I really appreciate if you watch this video all the way through. And I have to do another video like this next time. This was actually a lot of fun. And I appreciate all the commenters as well. Thank you. So like, subscribe, leave a comment, and click that bell below to get notifications. Thank you very much.